would like to start with an interesting program one, and now we have our second program. And we're kind of going to go way back in history. And nonetheless, the laws are very important today, especially in all the scholarly research that's out there. And Fred Bigladai will tell us all about. I'm not going to be able to pronounce it, so I'm sorry.
The Corpus Juris, Corpus Juris Civilis.
Civilis, that's it. Thank you, Fred.
Hi, thank you, Patty. Thanks to Val for hosting this, and thanks to Washington Lee for hosting the meeting. First off, can you hear me in the back? Excellent. Okay, so first a couple of introductory things. First off, there's going to be a handout that's going around. I've also posted the handout to the William and Mary Law Library Scholarship Repository, and also the slides I'm showing you today are going to be posted to that repository. So if you want to go to them later, just go to our repository, look me up, they'll be there. And second, I'm also going to say that I've sort of become recently interested in the Corpus Juris Civilis. I have not studied Latin, so if there's any Latin scholars out there, I apologize in advance for my pronunciation. So how did I become interested in the Corpus Juris Civilis? Well, some of you might have heard the plug, but I'm going to give you another plug for Wikipedia. This, of course, is the College of William and Mary Law Library's wiki on all things about George Wythe, our first professor of law in the United States. As I'll mention a bit later, George Wythe liked Roman law and would cite to the Corpus Juris Civilis fairly often. The more I read about Wythe, the more I read about the Corpus Juris Civilis, the more interested I became. Which brings us to today. What we're going to cover are the history and components of the CJC, then go to the relevance of the CJC, why are we still interested in it, and finally, how to research the Corpus Juris Civilis, which can be interesting. But let's begin in the beginning. There have been previous attempts made to codify or to compile Roman law before Emperor Justinian, who created the CJC. Way back in 450 BCE, you had something called the 12 Tables. This was the first attempt to make some sort of codification of Roman law. Then, fast forward a couple centuries to the 3rd century AD, and you have Emperor Diocletian. There were 2 attempts made to compile Roman law under Emperor Diocletian's reign. First, you had the Codex Gregorianus around 291, then the Codex Armogonianus in 295. Fast forward another century, and it comes Emperor Theodosius II. He again tries to compile all the edicts that have been handed down by the emperors over the year into something called the Codex Theodosianus. That comes out in 438. This is fairly successful, and actually this becomes the form of Roman law that is most known to Western Europe for a good part of the years before the Middle Ages. Then we get to the Roman Empire in 500. Now, by the 5th century Common Era, the Roman Empire had basically been split in two. You had the Western Empire, then you had the Eastern Empire, which was run out of Constantinople. Then, in around 476, the Western Empire falls, as most people consider it. So, when you're talking the Roman Empire, you're talking the Eastern Empire. Now, a lot of times these days, historians talk about the Byzantine Empire. They call it that because Constantinople's old name was Byzantium. But if they're talking the Byzantine Empire, they're still really talking the Roman Empire. If you ask anyone who lived in the Byzantine Empire, who ruled the Byzantine Empire, they still consider themselves Romans just as much as anyone who lived in Rome or Italy at the time. So, by 500, the Roman Empire is the Byzantine Empire. And that brings us to Emperor Justinian. Now, Justinian came from pretty humble beginnings. He was born Petrus Sabatius in Macedonia, and he was adopted by his uncle Justin. Now, Justin himself came from pretty humble beginnings. Justin was born a peasant, rose through the ranks of the military, and he eventually became the head of the imperial bodyguard. And then Justin was able to maneuver around the previous emperor's nephews, the previous emperor Anastasius. They thought his nephews were going to take over after him, but no. Justin manages to work around the nephews and becomes the next emperor after Anastasius. So, Justin adopts Justinian, his nephew, as his son. Petrus Sabatius takes the name Justinian to honor Justin's deed. And after Justin dies, Justinian becomes Emperor Justinian. Now, Justinian was a very shrewd politician, but not very well liked by the Senate, because as far as they were concerned, both Justinian and his uncle Justin were provincials, rustic, shall we say. They were not one of them. So they always did not care for Justinian. Also bear in mind, the history that we're getting about Justinian and his wife Theodora, this is coming from historians who probably came from the upper class. They also did not care much for these people from the rural provinces of the Byzantine Empire. So any history we're getting is through the lenses of these historians who, for the most part, did not seem to care for Justinian that much. So whatever information we get about Justinian might have to take with a bit of a grain of salt. What we do seem to know is he was very austere, seemed to keep those old habits back from when he was growing up poor. In one way, he was humble. He did not like to be called master or anything title like that. On the other hand, he was really not a humble person. He was sure he was destined to great things. Divine providence was making him the leader of the greatest empire that ever existed, and he was going to restore this empire to its former glory. So in one way humble, but really not so humble. He was a highly religious man, very pious man. One of his main goals as the emperor was to make the empire a truly Christian empire as he saw it. And he was going to purge it of all the pagans, purge it of all the heretics, any form of Christianity that did not agree with his version of Christianity, gone. Get them out of those ranks. He was a very dogmatic, I guess you could say, autocratic sort of person. It was pretty much his way or the highway. So one of his main goals, make his empire a Christian empire. Another one of his main goals, take back the Western Empire. Now, some historians think this was more of an aspiration than a goal because he had some early successes taking back the Western European former parts of the Roman Empire. As his rule progressed, he stops talking about it so much because he's not having so many successes. So some historians think that wasn't so much a goal as an early hope. But his other goal was to take Roman law and restore it to its former glory, because arms and laws have always flourished by the reciprocal help of each other. In order to have a military that can properly conquer Western Europe, to have an empire that can rule the old Roman Empire as it used to, you needed to have a law that made sense and that was a good set of laws. From Justinian's point of view, the problem was that by this time, Roman law was a mess. There were probably two major forms of law you had to deal with by Justinian's time. You had something called the constitutiones. These are basically edicts handed down by emperors. So they were kind of like laws or executive orders, but in another way, they were sort of like attorney general opinions. Because what would happen is some senator, some nobility would ask the emperor, what is the law on this point of view? And the emperor would say, I declare this is the law. So that's what a constitutione was, these imperial edicts. The more problematic part was these juristic writings. Now, the jurists were kind of like academic scholars, but if anyone is familiar with the European Court of Justice and they know the position of the solicitor, I believe it is, they also kind of acted like that, because not only would these jurists create writings that interpreted Roman law, saying, here's my new treatise on Roman law, they would also advise judges and litigators as to what they think the law should be in a particular dispute. So they were advisors to litigants, advisors to judges, but for our purposes, the important thing was that they were creating these writings that interpreted Roman law. By Justinian's time, centuries of these writings had been created, and these writings had a lot more weight than, say, you see in a common law system, but they were contradicting each other. So if one attorney could cite one jurist, this other attorney could pull out this other jurist and say, well, no, this jurist says this instead. So it was getting very confusing. Litigation was getting protracted. He needed to do something about this. Which brings us to 528. Justinian authorizes the first law commission. Two of the most important people on this commission are Tribonian. In a couple of years, Tribonian is going to become Justinian's questor sacri palati, basically the senior legal official in charge of writing laws for the empire. Right now, though, he's just a junior member of the First Law Commission, still working his way up the ranks. On the right-hand side, this is not an actual picture of John of Cappadocia, but John of Cappadocia is a very important person as well. He is the finance minister for the empire. The empire has pretty much burned through the surplus that Emperor Anastasius left. Justinian is trying to conquer the west. He's also having to fight off Persia on the east. There's been earthquake relief he's had to deliver. The empire is spending money left and right. And John of Cappadocia is very good at raising money through taxes. So he's one of Justinian's most important advisors, probably second only to his wife, Empress Theodora. So John of Cappadocia gets the place of privilege. He's the chair of this first law commission. What Justinian appoints this first law commission to do is that these constitutiones that all the emperors have handed down back to Emperor Hadrian, I need you to compile them, about 2,600 altogether. I need you to get rid of any redundant constitutiones, any constitutiones that contradict the law as it stands today, and give me a single body of law, this collection of constitutiones that states the law as it stands today in my era, Justinian's era. He realized that a lot of these things are going to need to be harmonized. Remarkably, 1 year later, they succeed. It takes only 1 year to take all these constitutiones and compile them into something called the Codex. The Codex takes all these constitutiones, gets rid of the redundant ones, gets rid of the constitutiones that contradict the law as it stands in Justinian's time, and it arranges them into 12 books. Each book is further divided into titles. So here's the main 12 books. As you can see, a lot of it covers private law. There's some discussion of public law, administrative law, so on and so forth. The books are divided into titles. Titles are organized into individual laws. Each law is organized chronologically. So it's not exactly a code as you think of it today. They're just organized chronologically within each title. So far so good. We've got the Codex. Unfortunately, Justinian realizes that's not going to do the trick. You still have all these centuries of juristic writings to handle. These Codex Constitutiones, these are very bare-bones statements of the law. This Codex is kind of intended to be a handbook for judges and for litigators to use to get a quick look at what the law is, but they're very bare-bones statements. They're not giving you the entire law. You still have these juristic writings to deal with that are still contradicting each other, that are still redundant, so we need to take care of that. One other thing I need to point out is, it's called the Codex. A lot of times you'll see it translated into code in English, but most historians say that's not really what this Codex is. The reference to Codex is that it is a codex. It is a book, pages compiled and bound between two art surfaces. That's what's meant by Codex. It's kind of more of a one-stop shopping for all the laws, all the constitutiones, as opposed to the Liber, which was another word that translates into book, but that usually referred to these papyrus scrolls that were sort of the older form of holding information. So that's really why they're calling it a codex. They're saying, here's a book that has all the constitutiones you need. So not exactly a code as we think of it today. 530, the second law commission is authorized. This time, Justinian makes Tribonian the head of the law commission. Tribonian has proved his worth. Tribonian is also a very charming man. He's very well learned. Supposedly he has the best law library in the entire empire. And he is also a very good administrator who has apparently proved his worth, at least by Tribonian's accounts, in the first law commission. So Tribonian heads the second law commission. And they're given two missions. First off, take all these juristic writings, compile them into something called a digest. Second off, Justinian wants this commission to create something called the Institutes. It's going to be based on Gaius' Institutes, an older treatise on law, and Justinian wants this to become sort of like an introductory text to Roman law. So these are the two main missions that the second law commission has to deal with. So they're going pretty well for a while. Then in 532, the work gets interrupted by something called the Nika riots. Nika is the Greek for victory, and well, here's what happens. Like I said earlier, John of Cappadocia was raising a lot of money for the empire through these taxes, and these taxes are hitting the upper class for the first time. Upper class not happy about that. Tribonian has changed the laws. One of the laws that he changed had to do with the law of succession. So some people are ready to inherit. All of a sudden, they're not inheriting anymore. They're not happy about that. There's also rumors circulating around John of Cappadocia and Tribonian. John of Cappadocia is supposed to be this depraved, immoral person who just sucks all the regions dry with his taxes. Tribonian is rumored to sell the amendment of laws for the right bribe. So if you need a law created or not a law repealed, send the right amount of gold to Tribonian, hey presto, there you go. So all these rumors are starting to circulate. People are not happy with the taxes and the change of laws. And on top of this, you have chariot racing. No soccer back then, no football. Chariot racing was the sport of the Byzantine Empire. And the place to watch chariot racing was the Hippodrome. You look right up there, you've got the Hippodrome kind of there on the left-hand side. And the Hippodrome was attached to Justinian's great palace, that gray area on the right. The Hippodrome was the major venue for chariot racing in Constantinople. Another reason why the public liked chariot racing so much, this was their best opportunity to actually confront the emperor, to let their opinions be known directly to the emperor. Now back then, there were two major fan clubs in chariot racing. You had the Blues, you had the Greens. And really, the Blues and the Greens were a lot like soccer fans are today. They were violent, they hated each other, and usually after every chariot race, they would riot and vandalize the city. But they were very important factions because they led the cheers during these chariot races. Now, Justinian had supported the Blues on his rise to power. Theodora had a special place in her heart for the Blues. They had helped her out earlier. Once Justinian became emperor, though, he stopped favoring the Blues so much, which they didn't care for too much. This all comes to a head in January of 532. There's a riot after one of the chariot races, and the prefect of Constantinople is following Justinian's new orders to treat both Blues and Greens evenly, he sentences 7 of the leaders of the riot to death, both blues and greens. The hangman botches the execution, the gallows breaks, and a blue leader and a green leader escape and manage to find sanctuary in a monastery. So Justinian sends his prefect's troops to surround these escapees, try and starve them out. But the blues and the greens, they want their leaders to be free. So Justinian tries to hold another race a couple of days later, and the blues and the greens, the first thing they do is say, we want our leaders free, let him free. Justinian says, no. So the races proceed. About halfway through the races, what usually happens with the cheering is each side cheers Nika, and then whatever the color is. So Nika, blue, Nika, green. This time, though, they have a common enemy in Justinian, they have a common cause, so everyone just starts chanting as one, Nika, 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 Nika. And then they storm the Kathisma, which is where sort of the imperial box where Justinian and Theodora are sitting. Justinian and Theodora flee to the palace. The crowd tries to storm the palace. It's too well protected, so they just torch the city instead. A couple of days later, Justinian returns to the hippodrome to confront the crowd. They say, all right, at this point, not only do we want our people freed, we also want you to get rid of Tribonian, John of Cappadocia, and your prefect in charge of the city. Justinian is terrified, says, okay, fine. The crowd realizes they're on a roll, though, so that's not enough. And now the Senate is interested. The Senate goes, this is our perfect chance to finally get rid of Justinian. So they go to the crowd and start suggesting to the leaders, you know, Anastasius' nephews are still around. Don't you think they'd make a great emperor? So the crowd takes the lead, and they start hunting down Anastasius' nephews. They finally come upon Hypatius, and they grab him, and then they start saying, congratulations, you're the new emperor. Hypatius says, what? And they say, you're the new emperor. Congratulations. A couple days later, Justinian tries to pacify the crowd. He swears on a pile of gospels, I will let you all free if you just stop and go home. It worked for Anastasius a couple emperors ago, but people know that Justinian is a tricky one, so they say, no, we don't buy it. They continue to storm it, and then they get ready to bring Hypatius to be crowned as the new emperor. Justinian's back in his palace, he's terrified. John of Cappadocia says, we need to go. Ships are ready, let's flee the city. The only thing that keeps Justinian from fleeing is his wife, Empress Theodora, probably his most trusted advisor. She finally says, now again, historians we think might have put some flourishes on her speech, but the basic idea is, she says, I'm not leaving as anything but an empress. Purple is the finest funeral robe. If I'm going to die, I'm going to die an empress. Theodora convinces Justinian to stay, and they figure out how do we get the city back. Justinian sends the head of his eunuch bodyguards to the head of the blue leaders. Now, we're not sure exactly what his goal was. Some people think the idea was to get the blues to leave altogether. Some people think, well, they just wanted the blues to start cheering for Justinian, create some discord between the blues and the greens. We know that the idea behind the bribe was create discord between the blues and the greens. Now, the head of this eunuch bodyguard, called Narses, also reminds the blue leaders that Anastasius, he was a green supporter. Do you really want a green supporter as their emperor? Well, it creates enough discord between the blues and the greens so that Justinian can send his troops in and just slaughters them all. Blues, greens alike, if they're in the hippodrome, they're dead. 30,000 people altogether. Hypatius and one of Anastasius' other nephews, Pompeius, they beg for their life. They say, we didn't want to do this, they forced us, and we think Justinian might have been inclined, but then either he realizes or Theodora points out that there's still rallying points for the opposition, so he has their heads cut off and their bodies tossed into the sea. The senators who spurred the crowd into picking Hypatius, they're exiled, the property is seized. So this is a major turning point for Justinian's reign. First off, this interrupted the work on the digest, because you can't work on a digest when the city is burning around you. Second off, Tribonian was removed as the questor sacri politi, but he was still the head of the Second Law Commission, so they could still kind of work on it. Also, we think Justinian might have rushed the schedule of the digest because he said, I need a PR coup after this. So they think that the digest might have been rushed even further than it was already. But probably most importantly, Justinian had secured his reign. His Senate opposition was crushed. Now, the rioters wouldn't be completely quelled, but they realized that he was not going to be nearly as lenient as, say, Anastasius had been, so they're going to be much more careful about trying to oppose him openly. So the Nika riots, very important part of Justinian's reign. After all this, though, 3 years later, the digest is finished. Also called the Pandex. Pandex is a term meaning complete digest, complete body of law. So sometimes you'll hear the digest referred to as the Pandex. The fact that this was completed is a remarkable achievement. It was thought that this could not be done, taking these 2 million lines of juristic writings and compiling them into one collection. Theodosius II had tried it a century before and failed, which really made Justinian want to do it that much more, because if this is something Theodosius II hadn't done, then surely the great Justinian could do it, and finishing the digest would show Justinian's great glory and the divine providence that shines upon the empire by completing this task. Also, the Visigoths had created their own compilation of Roman law called the Lex Romana Visigothum, or something along those lines. And this was sort of the form of Roman law that was being applied to Western Europe at this time, sort of Roman law, the Codex Theodosianus, influenced by Germanic traditions. And Justinian said, well, if the barbarians can do this, surely the great Roman Empire can do this. So all of this is saying, 3 years, we completed a digest, divine providence is surely shining upon us. It took these 2 million lines of juristic writings and organized them into 50 books. Each book was divided, all the books were divided into 432 titles. Again, as you see, the vast majority of it had to do with private law, some other topics also covered. Now, these juristic writings are there mostly to fill in the gaps that the Constitutiones don't cover. Kind of like the restatement is today, and the restatement authors even said they were inspired by Justinian's Digest. Some people see Digest and you think case law that must interpret the Constitutiones. It's not interpreting. Again, it's more to fill in the gaps, not interpret the Codex. Now, these 432 titles are again further subdivided into laws, and here is kind of where the problem comes in. Now, this person here, Alan Watson, describes the Digest as an appalling arrangement, and he is right. Because all these juristic writings, these were created by jurists who wanted to make themselves, again, they wanted to raise their name in the empire. They wanted to improve their reputation. The way you improved your reputation was creating new juristic writings, new treatises. There is no glory in creating an organization system for these treatises. You know, just like no one wants to have their name put on the sewage system, they want their name on a nice shiny new building. These jurists wanted to create new treatises. They don't care how you organize them. So they were sort of organized in this kind of slapdash, thrown together organization system called the Edict. And the Edict was more or less what the Digest used to organize these juristic writings into the 50 books and the 432 titles. And once you get within each title, the way that they organized the laws within each title was kind of interesting. What happened was Tribonian took the Second Law Commission, broke it up into 3 subcommittees. Each subcommittee took a certain group of jurists and tried to compile them, analyze them, synthesize them into something smaller. So maybe subcommittee 1 would take Oppian, subcommittee 2 would take some other jurists, and then they'd get back together to compare and collect their work. So here's pile 1. Here's subcommittee 1's work. Pile 2. Here's subcommittee 2's work. Pile 3. Subcommittee 3's work. And we think in the room behind them, they had 432 cubbyholes for 432 titles they needed to organize these writings by. So they start taking pile 1. Okay, this goes here, this goes here, this goes here, and they're finished. Pile 2. This goes here, so on and so forth. That is how the laws are organized within each title. The first part of the title is the laws that Subcommittee 1 looked at. Second part of the title, the laws that Subcommittee 2 looked at. And then Subcommittee 3, and then an appendix that we think Subcommittee 3 also looked at. That's how they organize the laws within each title. Not even chronologically, just here's what the first group of people looked at, here's what the second group looked at, here's what the third group looked at. So again, trying to find something specific, not the easiest task in the world. But they have done it, and they have done it in 3 years. And today, modern scholars consider this digest probably the most important part of the Corpus Juris Civilis. Also, that same year, the Second Law Commission, as sort of a subcommittee, finishes Justinian's Institutes. As I mentioned earlier, this was based on a treatise by an earlier legal scholar called Gaius's Institutes. It was sort of updated for Justinian law. This was meant to be the first-year legal textbook for law students, but it was still binding law in and of itself. And since this is meant to be an introductory text, it is actually a lot better organized than the Codex and the Digest are. 4 books: persons, things, obligations, actions. So this is what your first-year law students would now be reading in the legal course in the Empire. Which brings us to the reform in legal education. There were several law schools across the Empire, but there was really no solid curriculum. Different professors would assign different collections of juristic writings and constitutiones. Justinian wanted to reform that. He wanted to raise the quality of lawyers, officials, and judges in the empire. Also, he wanted to give people, intelligent people, a reason to keep reading Latin. By Justinian's time, the Byzantine Empire, Greek was by far the strongest, most important language of the empire. Justinian was born a Latin speaker. Tribonian, they could both speak Latin and Greek, but Tribonian also preferred Latin to Greek. They wanted to give people a reason to keep studying Latin. So they figured, what we do? We give them law courses in Greek, but the reading is in Latin, so they're going to still have to study Latin. So we organized this legal curriculum. First year, the students read the institutes. All throughout the course, they read the digest and the novels, which I'll get to in a minute. And the fifth year, we finish off with the codex. Justinian also authorized 3 schools. One would be in Rome, one would be in Constantinople, one would be in Beirut. Now the Beirut school gets wiped out by a tsunami in 551. They try and reorganize, but it's not the same. All the professors have pretty much fled to Constantinople, so Beirut doesn't last much longer. And these students would also be given cheap copies of the digest, the codex, and the institutes. So the idea was that lots of people would be able to read these publications. Justinian was even sending the digest, the codex, and the institutes to Western Europe. By this time, he'd retaken Italy. Italy got a copy of all of Justinian's works. You know, they're a little price for you. Hey, we conquered you, here's your free book. Now, 534, Justinian realizes there's still a problem with the codex. The juristic writings, again, contradicted and were redundant with a lot of the constitutiones, and the old constitutiones that were collected in the first codex, they were kind of out of date with Justinian law. So Justinian had handed down a lot of decisions since the first codex came out. Probably the most famous are what we call the Quinquaginta Decisiones, the 50 decisions, although it's more like 150. These are laws that Justinian handed down, trying to harmonize those older codex constitutiones with the law as it stands today. So 534, they say, we need a new edition of the codex. It incorporates those Justinian laws into a second edition. This second edition, that's what we find today. Versions of this Corpus Juris Civilis you see today, it's the second edition of the codex that it has. First edition is pretty much lost to time. Now, the novels, or what we call the Novelli Constitutiones, these are basically Justinian's Constitutiones. So the laws that Justinian hands down during his reign. Originally, Justinian had a plan to compile all of these Constitutiones so that he could send them to Western Europe, the new recollected Western Roman Empire. Never comes to fruition. We have to wait until after his death for some private parties to conduct these Constitutiones. 565, Justinian dies. Now, in some aspects of his reign, he was actually very successful. 555, he has taken back a good chunk of the Western Empire. He's taken back Italy, he's taken back southern Spain, a good chunk of northern Africa, all back as part of the Roman Empire. But this came at horrible expense, and his successors are just unable to maintain those gains. So a couple centuries later, we got the Byzantine Empire in 717, and it's back to these little fragments of what it once was. They still hang on to parts of Italy, but mostly it's Asia Minor. That's what it's back to. So Justinian's laws never really have a chance to take hold in most of Western Europe. They got there long enough so that people are still familiar with the Codex and the institutes. The Digest has pretty much been lost for a couple of centuries. So they never really ruled Western Europe. It's more of those combinations of German traditions and the Roman law from the Codex Theodosianus. That's what's ruling Europe, kind of depending on what part of the continent you are. For the North Europe, the greater the odds that you're getting more of the Germanic traditions. The southern part of the continent, the part that had traditionally been Roman law, you still have a fair amount of Roman law because a lot of those Germanic tribes, they actually respected the Roman institutions and they tried to maintain them as much as possible, but they still worked their traditions in as well. Even within the Byzantine Empire, the eastern part, Justinian's laws, as Justinian wrote them, they start to fade over the years. Justinian originally intended, said, these laws are perfect. You shall not cite to any other law besides those in my compilations, the digest, the novels, the codex, and the institutes. You do not need to amend them. You do not need to cite to anything else. I forbid you to cite from anything else. He even ordered the commission to destroy some of the copies of the law that they had based the work upon. He allowed an exception for translations, abridgments, and indexes, and some people took that and ran. And as the centuries passed, Greek became more and more the language of the empire, Latin less and less the language of the empire. Also, these Justinian works are referring to institutes that later emperors have no idea what they're talking about. So later Byzantine emperors are changing the laws. Leo the Wise issues something called the Basilica, which is basically Justinian's works but amended for Leo the Wise's age. So even the Corpus Juris Civilis, as we know it from Justinian's time, by the end of the Byzantine Empire, looks fairly different from the way Justinian wrote it. Still, Justinian's works start to lose their influence until the medieval revival in Western Europe. Why the sudden resurgence in interest in Western Europe in Justinian's works? Well, there were a few reasons. A lot of the medieval scholars, they consider Justinian's works to be reason in writing. Another reason, the digest had pretty much gone missing from Europe for several centuries after Justinian's reign. There were a couple of copies lying around, but Western Europe, they just didn't know about them. Then, middle 12th century, the Pisans managed to find something called the Littera Florentina. This is basically a totally intact copy of Justinian's digest that was found in a part of Italy that was still ruled by the Byzantines. So the Pisans steal this part of Justinian's works, this Littera Florentina, they take it to Pisa. Then it gets moved to Florence eventually. That's what's called the Littera Florentina. So the digest, which had gone missing, they found it again. And all of a sudden they're interested in Justinian's works again. Another possible reason is that the popes and the Holy Roman Emperors are fighting each other to say who is the dominant force in the Holy Roman Empire. Each of them is citing the Roman law to support their claim to, I go all the way back to the ancient Roman emperors. So another reason is someone called Matilda of Canossa, very interesting person. Her father was a very powerful landowner, but Holy Roman Emperor Henry IV, he used the law of the Germanic traditions that ruled the empire at the time, and he deeded her land to her husband instead, Godfrey the Hunchback. And Godfrey the Hunchback wills his land to his nephew. So he's trying to do a complete end run around Matilda of Canossa. Now Matilda knows Roman law, she would be allowed to inherit, unlike the Germanic traditions. So she says, wouldn't it be great if Roman law ruled here instead of Germanic traditions? So she still has a fair amount of resources available to her, and she encourages scholars to start learning Roman law and spreading the word again. One of the most important scholars is Irnerius. He is one of the first of the scholars to really pass Roman law around during the medieval era, and we call him the first of the glossators. So Matilda of Canossa encourages Irnerius to study Roman law in Rome. Then Irnerius goes to the University of Bologna and starts spreading the word there. The University of Bologna becomes one of the preeminent centers of legal learning for the entire continent of Europe and starts the revival of the Roman law in the continent. So we think that Matilda of Canossa might have been one of the major forces behind this. So Irnerius is the first of what we call the glossators. They're called this because what these scholars would do is they would take Justinian's works and they would add glossi, basically commentaries that would update Justinian's laws for their time. There are several other glossators. The other important one, though, is Accursius. Accursius was sort of the last of the major glossators. He took all his predecessors' work and he compiled them into one collection that we call the Glossa Ordinaria. And this was like the final collection of glossae for the medieval era. Like you see there in the middle, there's the Justinian work. Then around the edges, we have the commentary that all the glossators have added over the years. Now, the Littera Florentina that I mentioned earlier, this is like almost totally intact version of Justinian's Digest. We think the glossators knew that it existed, but we don't think that they used it when they were making their version of the Digest. Their version of the Digest, we think, was more cobbled together from different fragments that had been discovered in Western Europe over the years. And they compiled them into something called the Vulgata. And the Vulgata is eventually divided into three parts, sort of based upon when they discovered these different fragments. Got the Digestum Vetus, the Infortatium, and the Digestum Novum. Now this is not a perfect recollection of what Justinian's works were like. So a lot of the Greek parts are either left out or just very plainly translated. Other parts are left out just because they couldn't find them, or they were translated in different ways, depending on which philosopher did it. So it's not a perfect recollection of Justinian's works. Also what's happening is the glossators are adding more commentary, first around the edges, but eventually they're working it into the text itself. They're adding some of Justinian's novellae to the digest. They're also adding laws that the Holy Roman Emperors have handed down over the years. So this is kind of Digest Plus. The Codex was more intact than the Digest, but still not perfect. What would happen is the glossators, the Codex in their time was just the first 9 books of the Codex. The other 3 got put into a different volume called the Volumen. So the last 3 books of the Codex got put into something called the Tres Libri Codicis. Also have the Authenticum, which is a lot of Justinian's novellae. The Libri Feodorum, these are basically laws that the Holy Roman Emperors had handed down. And the Institutes, well, the Institutes actually managed to be fairly well intact. So fairly influential compared to some of the other parts of Justinian's works. And again, they're starting to mix some of these parts. So some of the Libri Feodorum, some of these laws from the Holy Roman Emperors, are starting to get incorporated into Justinian's laws during the glossators' time. Then we get to about the 16th century. Dionysius Godefroy, Godefroy. He comes up with the first collection of Justinian's works called the Corpus Juris Civilis. This is the first version of the Corpus Juris Civilis that is called the Corpus Juris Civilis. And also, Godefroy, he takes Justinian's works and he organizes them into the units we know of today: digest, codex, institutes, and novelli. So this is a big sea change for the study of Justinian's Roman law. Now you go to the English-speaking world. 1753, an attorney called George Harris, he creates the first English translation of any of Justinian's works, and it's the Institutes. So the 4 books of Justinian's institutions. For a long time, if you couldn't speak Latin or Greek, and you only spoke English, the Institutes were the only part of Justinian's works you had access to. So in the English-speaking world, the Institutes had a very outsized effect on the scholars compared to the other parts of Justinian's works. Now, fast forward another century or so, we get into the codification movement of the 18th and 19th centuries. These city-states are compiling into larger countries. Each country says, we need to come up with our own set of laws different from other parts of Europe, like the Code of Napoleon in France, German Civil Code, Spanish Civil Code, so on. Germany was kind of late to the party. First off, because Germany wasn't even a country until the late 19th century. Second off, they did a lot of debating. First off, do we need a code? Then, what do we base the code on? You had the historians who thought we should base it on Germanic traditions. You had the Romanists who said, no, base it on Roman law. The Romanists went out. So, even within the Romanists, there's more debate. Do we base it on the Glossators' works, these medieval laws? Then you had the Pandectists. Pandectists said, no, we need the Roman law as it was in Justinian's time. Of course, by this point, the Glossators have been incorporating different things into Justinian's works, so they need to find out first, what did the law look like in Justinian's time? This is important because a lot of the important scholarship on discovering that old Justinian-era Roman law is from this time, from the German Pandectist scholars. Theodor Mommsen, he creates sort of the gold standard original language edition of the Digest that we still rely on today. Paul Kruger, he does this gold language version of the Institutes and the Codex in their original language. And finally, Rudolf Scholl begins, and Wilhelm Kroll, he finishes work on creating that gold standard original language version of the novels. And to this very day, scholars say these are the original Latin, Greek versions of Justinian's works that are closest to the originals. Back in the English-speaking world, 1904, we get the first English translation of the Digest, part of it anyway, by Charles Henry Munro. Then comes S.P. Scott in 1932, another interesting fellow. He was originally a businessman. Then later on in his life, he decides he wants to start translating Latin works. Because, why not? So, S.P. Scott translates a lot of major Latin works, and then he says, you know what, I want to translate the Corpus Juris Civilis, all of it. And he does it, which is a very remarkable achievement. Here's the problem. Most Roman law scholars don't think it's a very good translation. Couple of issues. His literary Latin was very good. He was not a Roman law scholar. His legal Latin, not so good. And as you know, when it's just about any language, legal language and the normal form of language can be two entirely different beasties altogether. So they think A, he was mistranslating some of the legal Latin terms. B, he did not have access to that German legal scholarship, or at least he did not read it, even though there was, like, I think University of Dayton had a library with most of the German law scholarship, which was not far from where he lived, never visited. So people think that he did not realize he was using the wrong original language version of the CJC. He was using that Vulgata and those other glossator works back in the medieval era that was getting stuff incorporated. So he was using the wrong version of the original language stuff. So a couple of errors here. The fact that he did it all is still remarkable, but at most, scholars might concede, well, it's better than nothing. Then we come to other translations of parts of the CJC. 1985, Alan Watson, now a professor at the University of Georgia. English translation of the Digest, still considered the best today. 1952, jumping back in time, Justice Fred H. Bloom, Supreme Court Justice in Wyoming. He was a native German speaker, born and raised in Germany, emigrated to the United States, had access to all this German scholarship on Roman law, also wanted to translate Justinian's works. At first he hears that this S.P. Scott fellow is translating and says, well, I don't need to do this again. Then he reads Scott's translation, or at least enough to say, no, I do need to do this. So he translates the Codex and the novels into English. His is meant to be more of a plain English version, at least a plain enough English version so that attorneys can use it. So this is meant to be like a practitioner-oriented version of Justinian's works that lawyers can use. His version never gets published in his lifetime. Tries to get published a couple times, but the publishers who are interested are busy with other Latin works at the time. Never gets done. Fortunately, University of Wyoming has taken these translations, put them on a website for free. Also, Cambridge University Press is going to publish Justice Bloom's translation of the Codex in July this year. So it's finally going to be formally published. That's sort of the brief history of the Corpus Juris Civilis. So why is it relevant? Why are we still interested in the CJC today? Well, the Corpus Juris Civilis is very influential, especially in continental Europe and these civil law jurisdictions. France, the Code Napoleon. Even though maybe most of the laws don't translate from Justinian's works to the Code Napoleon, the structure, the subjects that are covered in the Code Napoleon, you'll see they track the institutes very closely, the way they're organized, the subjects they cover. And the Code Napoleon itself was very influential on other countries' civil laws. Germany's civil code, Spain's civil code, Italy's civil code. Spain also had another thing called the Las Siete Partidas. This was a body of law that was created, that was passed in the 14th century, and was still, at least partially, the law in Spain all the way through the 19th century. And a good portion of the Las Siete Partidas was taken from Justinian's Digest almost full scale. So, very influential on these European nations. But what about the common law world? Well, again, we're common law, England is common law, we're not civil law jurisdictions, but Justinian's works still have some influence. Back in the 13th century, Henry de Bracton writes a treatise called On the Laws and Customs of England. And he cites to Justinian's works quite a bit in that publication. He's fairly influential in his lifetime, then he dies, not so influential. But then someone during the Elizabethan era decides to publish Bracton on the Laws and Customs of England again, and all of a sudden he is influential again. And people are citing the Roman law. Sir Francis Bacon cites to Justinian on the idea that you should get rid of any repetitious laws. Also, American scholars, the people in the American colonies, they also like to cite to Henry de Bracton. A lot of times in the courts, they will cite it in their cases against the crown. Also in England, you have these lawyers called civilians. Basically, these are specialists in the civil law. So if there's a topic that the common law doesn't cover, sometimes they'll consult these civilians and say, well, what would the civil law say that we need to do? Admiralty law, heavily influenced by continental European jurisdictions. So admiralty law, even in England, is fairly influenced by Roman law. Ecclesiastical law, even the English churches, the Anglican churches, that law is still influenced by the Roman law that the Roman Catholic churches used before. Those courts of equity heavily influenced by the Roman law. So even though we're a common law jurisdiction, we still have some heritage from the civil law as well. Some American scholars, besides citing civil law against the crown, would also study civil law during the colonial era to distinguish themselves from their less learned colleagues. Unsurprisingly, John Adams was one of these people. He would even say, let me therefore distinguish myself from my colleagues by the study of the civil law in its native languages. So not only was it another tool you could use against the crown, it was a way to show just how dang smart you were compared to some of your other attorneys. Now, our own George Wythe liked the Roman law because he liked some of the Roman law principles compared to the English common law principles. If you look through Wythe's decisions, you'll see he was not always a fan of the English common law precedent, thought that sometimes Roman law had the better idea. So there was a fair amount of citation to the Roman law in George Wythe's decisions when he was the Chancellor of Virginia. Now, the Virginia Statute of Descents and Distributions in 1785 also heavily influenced by Roman law. In fact, a century later, after it was passed, well, half century, a justice notices that you'll see that the statute is almost entirely borrowed from one of Justinian's novellas. And the important thing about this is, this statute got rid of all primogeniture in England, and in Virginia at least. Because in Virginia before that, it was pretty much very male-centric, the line of descent. This changes so that basically whoever was next in line, male or female, was able to inherit. It's a very important development, and that was borrowed from the civil law, from the Roman law heritage, overriding English common law precedent. The restatements, the American Law Institute, sort of tips their hat to Justinians in their statement when they first came out with the restatement, saying that no project since the restatement has been undertaken since Justinian's Digest. So even though the law doesn't translate, the idea of taking all of these writings and compiling them in one place, inspired by Justinian. Today, we don't really see many citations to Justinian in the courts. Mostly it's just if a judge once says, well, we have had this law since the times of the Roman Empire, then they'll cite to Justinian. Other times when you might want to use Justinian's works is if you're trying to research what law was like back in the Roman Empire and in the Roman Republic, because again, Justinian had some of the copies of those old Roman laws destroyed before his time, and since you were only supposed to cite Justinian's works, people didn't have much interest in preserving those older Roman laws. So you need to look at the older Roman Empire, what the laws were. Justinian's Corpus Juris Civilis, probably your best option. Most of the time you find something older than that is because someone has used it as those older versions of Roman law as a palimpsest. So like someone goes through this old religious tract and say, oh, this is actually Gaius's Institutes. That's how we have a copy of Gaius's Institutes today. It's got some monk, they painted over all the pages, made a new book called palimpsest. That's how we have some of these older versions of Roman law. For the most part, going to Justinian's works. Want to know what the medieval law was like? You go to the Glossators' works. Now, how do you research the Corpus Juris Civilis? Well, here's the problem. Now, these are two of the authors of one of the major textbooks on Roman law, and they admit classification was not the strength of Roman jurisprudence. They borrowed it enthusiastically from the Greeks, but they proved to be relatively inept. So, not very well organized. Then what do we do? Well, what do you do when you're unfamiliar with an area of law? Go to the secondary sources. Borkowski's textbook on Roman law, Cambridge Companion to Roman Law, two good starting points. Justinian's Institutes, the original introductory text to Roman law, good place to start. A couple of the translations by Thomas and Sanders, if you look at your handout, you get the more specific citations. They also have commentary that gives you more detailed references to other parts of the Corpus Juris Civilis. Also, what can happen is, if you get a citation to the Corpus Juris Civilis, here's how to make sense of it. The handout has more details. Basically, during the medieval era, they didn't always copy the book numbers and title numbers over to the medieval versions of the Corpus Juris Civilis. So you might get some interesting sites. Instead of giving you a book number or a title number, they'll just give you the short title of the book and the short title of the law instead. As the years progress, the citations get more and more numerical until we get to Edward Gibbon, the man who created the history of the decline and fall of the Roman Empire. He comes up with the cite format that we use today. First letter tells you what part of the Corpus Juris Civilis you're looking at. Digest, Institutes, Codex, or Novelli. Next, you get the book number, title, law, paragraph, and section. Largest to smallest. The Novelli are a little bit different. They're just organized by law number. They are organized in the books. Now, of course, those of you who dealt with the Blue Book know that it has to do things differently. The basics are still there. They just want you to spell things out a little more. With the Codex, they want you to say which emperor handed down the law, what year it was handed down. The Digest, they want you to give the name of the jurist and what book it came from originally. And the Novelli, they need to tell what year the Novelli was handed down. Other ways you can search the Corpus Juris Civilis. As I mentioned earlier, Justice Bloom's translation is now available on a website at the University of Wyoming. As far as I know, they still plan to keep this up even after the book version is published. You can do a Google search. You can also browse the table of contents. Also, there is a translation table for novels, for Novelli to a Codex section. So if you need to know what Novelli interpreted a Codex section, you can do that. Now, Alan Watson's translation of the Digest has a Google Books preview that you can use. Again, it's a preview, it's not the whole thing, but at least it'll be enough to figure out what part of the Digest you need to be looking at. Archive.org, the Wayback Machine people, they also preserve a lot of books in online form, and a lot of those public domain versions, the gold standard original language versions of the Digest by the Pandectus, those are available here. Some of the older English translations, like some of the older English translations of the Institutes, the original Digest translation, you can get those here and do kind of a PDF style search. Also, lots of download options, download as PDF, as Amazon format, what have you. Now, I know, as we mentioned earlier, Heim does not have the greatest search engine in the world, but it does give you some advanced features. So that might be an option for some of these books. For example, S.P. Scott's version of the Civil Law, that's available on Heim. Some of the translations of the Institutes and the Digest, the Institutes, also available on Heim Online for alternate searching. Now, if you look at your handout, I mentioned that there is a website from something called the Constitution Society that has a free online version of S.P. Scott's translation of the Corpus Juris Civilis. I tried to do some research of this Constitution Society, and I could not find much information. And it's also like translated into text. I don't see why they'd have any reason to change the text, but again, use with probably a bit of caution because I don't know what this organization is or how accurate the transcription is. And of course, there's good old print. All these print translations will have a table of contents. At least it's going to be English and Latin in parallel, sometimes just English. And of course, there's indexes. For some odd reason, the digest versions, either translation by Watson or Monroe, do not have an index. But, well, you got the Watson Google Book preview you can use. They do have a table of contents, though. And so that is my brief introduction to the Corpus Juris Civilis. Thank you for your time. Questions?
Wow, so thank you, Fred. That was, you took us through from the way beginning to now, and so much that I feel smarter.
Yes.
Fred, that was great. Thanks so much. Maybe you said this in the very beginning, but I don't recall. Maybe repeat. So how over what span of time did you compile this body of knowledge you have? When did this project start? I know you said it was Wikipedia, but how long have you been researching this?
Well, my original plan was to make this as a presentation for VALL in Philadelphia. So well, the main program committee rejected it, but then the Roman Law Interest Group said, we'd like to hear you say that. So the first version of this took probably about 9 months, with a little bit of tweaking here. The main body of the research was about 4 or 5 months. Then, as I do more study, the more you learn. So the first version took 9 months. Then I did another version in New Orleans last year, so I did maybe another couple weeks of tweaking. And I'm now currently working on an article version of this presentation, and so the more I research for the article, the more things I discover that I can add to the presentation. So that's probably been another 3-4 months, so about at least a year and ongoing. Things like, just when you think you've finally got everything, you do some more research and you go, oh, no, there's more to learn. So it's, I'm enjoying it, that's it, yeah.
Have you consulted with other scholars, professors in various law schools about this, legal historians, other people, branched out and have met with people who have the same interest?
That's not a bad idea. I found with talking with Tim at the University of Wyoming, he's sort of like been one of the forces behind, I think it was one of the forces behind putting the translation of the Codex and the Digest from Justice Bloom at the University of Wyoming's website. So I talk with him now, every now and then, mostly just sort of mention what I've done. That's not a bad idea.
Yeah, it seems like there's a lot of it that benefit a lot of it. It's great. So,
yeah, you can just like
class or something with this.
Oh.
With some of that way the merry. I think that would be a great lecture just in general.
Oh. Yeah, that sounds like a good idea. But yeah, even just like going to like message boards and people reading new articles and new books, you keep discovering things like more information on philosophers, more information on the Nika riots, keep discovering more and more things about Justinian. So yeah, good point.
Have you used the classes department at William & Mary?
I have not. That would be a good idea.
That would be good, yeah. But you probably have covered most of it, but you never know.
I know, it's like every time I think I've got it covered, I learn. Well, except for this part.